Could I please ask everyone to turn their mobile devices to silent? Thank you very much, and we will be commencing shortly.
Silence, all stand.
All persons having any business before this honourable court now draw nigh. Give your attendance and you will be heard. God save the Queen.
This is a special sitting of the District Court of New South Wales to mark the retirement of His Honour Judge Norrish QC.
I would like to begin by acknowledging the Gadigal people of the Eora Nation, the traditional owners of the land on which this place, the District Court of New South Wales, now sits, and pay my respects to their elders, past, present and emerging. I extend a very warm welcome to all of you attending this ceremony, either in person or by virtual means. This special sittings has been convened to farewell a much admired judge, Judge Stephen Norrish QC. Judge Norrish, you have served the court with distinction for over 20 years. When you were sworn in as a judge on the 3rd of October 2000, you were a leading practitioner at the criminal bar, having been appointed Queen's Counsel in 1987. Although I intend to focus upon your contribution to the work of the court, I will briefly mention that your distinguished career included working as a solicitor for the Aboriginal Legal Service, your appointment as a public defender in June 1980, and elevation to Deputy Senior Public Defender 7 years later. In 1988, you resigned from your position as Deputy Senior Public Defender to become Senior Counsel, assisting the Royal Commission into Aboriginal deaths in custody, a role you performed until 1990. I will leave it to those who follow to speak in more detail about your career and service to the community. At your swearing in as a judge, you refer to the qualities you observed in Hal Wooten, ACQC, the Royal Commissioner, as being a combination of insight, intelligence and compassion, and you express the wish that some of the qualities that Commissioner Wooten displayed you would bring to the court. Judge Norrish, you have undoubtedly done so. Upon your appointment as a judge, you were immediately thrown into the criminal work of the court. You have presided over many difficult trials and sentenced many offenders. You have presided in Sydney and on circuit. Your intelligence, thorough knowledge of the law, sense of fairness and compassion are well known to all of those who have appeared before you, as is your expectation that lawyers be prepared and be able to provide appropriate assistance to the court. The burdens of judicial office did not diminish your concern for the treatment of First Nations people in the criminal justice system. You have delivered speeches and written articles on this issue. Your reflections on the Royal Commission and suggested reforms are a featured article in this month's Judicial Officers Bulletin. You have been the court's leader in developing and encouraging judicial participation in cultural awareness programs. You were a foundation member of the Judicial Commission Joint Steering Committee with the ALJA Aboriginal Cultural Awareness Program and the chairperson of the Judicial Commission's Nara Committee for some years. Your contribution to the court cannot be properly understood without further mentioning the person that you are. Your warm, welcoming personality, coupled with generous offers of assistance, made you a judge who your colleagues would consult when issues both personal and judicial needed to be discussed. Your famous handshake, proffered to any judge whom you encountered, brightened up the day of many of us. How we all suffered last year when we were restricted to a Norrish wave or elbow exchange. Permit me to return to your swearing-in speech. You recounted that you had been given the Book of Irish Laws, a book that set out the laws of the Brehons, jurists who travelled around Ireland dispensing justice until the completion of the English conquest in the early 17th century. A particular law that was drawn to your attention was one that stated, I quote, "When a judge deviates from the truth, a blotch will appear on the cheek." I am confidently able to state your expression of hope that your career on the bench would be spent without any facial blemishes emanating from breaches of ancient Gaelic law has been fulfilled, your beard notwithstanding. Most importantly, you leave this court being held in the highest esteem by your colleagues and by the members of the legal profession. During your judicial career, you have demonstrated the best qualities expected of a judge. This is a nostalgic occasion for the District Court. When you were sworn in as a judge, there were 21 judges of the court who had been conferred by the Crown with the office of Queen's Counsel. You are the last District Court judge who is entitled to the post-nominal QC. I'm afraid to say that you are the end of an era. Thank you for your service to the court. On behalf of your colleagues, I wish you and Joanne a very happy and healthy future. We will miss you. Mr. McHugh.
May it please the court. The Gadigal people are the traditional custodians of the land on which we meet, and I pay my respects to their elders past and present. I acknowledge the role of our legal system in perpetuating injustices against Aboriginal and Torres Strait Islander peoples and pay tribute to those who seek true equality before the law. That is a shortened version of an acknowledgement of country delivered by Chief Justice Bathurst at a District Court conference, and seems particularly apt today. For Your Honour, Judge Norrish QC is one who has sought true equality before the law. Equality before the law ought not be contentious, nor should it require quite so much explanation as it does. As Your Honour has cited more than once, Waters Public Transport Commission, 173 Commonwealth Law Reports, discrimination can arise just as readily from an act which treats as equals those who are different, as it can from an act which treats differently persons whose circumstances are not materially different. It is my privilege to speak this morning on behalf of the New South Wales Bar at Your Honour's ceremonial farewell. It is a chance to pay due respect to a half-century spent in service to the community, whether in the profession of law, on the bench of the District Court, or in forthright defence of the most vulnerable Australians. This ceremony has attracted much interest, and members of the Bar and the wider legal profession have asked me to convey their apologies that time does not permit me to fully set out. Other than John Purnell from University Days, who gave me an anecdote in return for that mention. Judge Norrish QC, in an off-cited conference paper, Your Honour has said, many Indigenous Australians are on a treadmill of despair, leading to desperation and failure from which increasing numbers cannot escape. The figures for incarceration rates and offending frequencies tell us this more clearly and eloquently than words. The criminal law, Your Honour has said, is a hopelessly blunt instrument of social policy. Your Honour has drafted numerous articles, conference papers and submissions citing what Your Honour has called the irrefutable truths and a vast body of unimpeachable sources on multifactorial disadvantage to assist judicial officers in their task of delivering individualised justice. This combination of knowledge, insight and compassion has been the hallmark of Your Honour's career, both on and off the bench. There were early portents. Your Honour completed a Bachelor of Arts in May 71, followed by a Bachelor of Laws at the University of Sydney. It was a time when the anti-Vietnam War movement and Aboriginal land rights struggle coalesced and contributed to a political awakening in many young people. Upon graduation, Your Honour was admitted as a solicitor of the Supreme Court of New South Wales on 8 March 1974, and Your Honour went to see a friend from university, Peter Tobin, at the new federally funded Aboriginal Legal Service. You were hired more or less on the spot and dispatched to Cowra, where Your Honour lived among the marginalised Indigenous community, the fringe dwellers, as author Nini Gare had called them in 1961. For the next 5 years, your peregrinations between country courthouses took Your Honour to Bathurst, Dubbo, Condobolin, Griffith, and as far east as Queanbeyan. I can recommend a YouTube video, Stephen Norrish in the Story Project, 40 Years of the ALS, and in which Your Honour reminisced about the formative years of the ALS. We learnt that much of your time was spent on the road. Your car was your office, a yellow Ford V8 with a rhubarb that was twice impacted on a single night on a lonely road between Wilcannia and the town of Nevertire. On the back shelf of the car were 2 or 3 of your favourite CLRs, which became yellowed from the effect of the sun. A number of those long drives were shared with Peter Hidden, then a junior barrister at the private bar, who has many fond memories, including the fact Your Honour had only one cassette tape, which was Stevie Wonder's Inner Visions. Your Honour became the principal solicitor in Redfern from 1978 until called to the New South Wales Bar, as we've heard, on 16 June 1980, whereupon Your Honour was appointed as a public defender. It was around this time that Senior Public Defender Howard Purnell QC mentored and led a team of criminal lawyers brimming with talent. Your contemporaries included Paul Byrne, Peter Hidden, Charles Lilland, Michael Adams, Bob Belier, Virginia Bell, Rod Howie and Greg Woods, as they were then. Each would go on to careers in the Judiciary, the Law Reform Commission or the Criminal Law Division of the Attorney General's Department. As Your Honour noted in a 2002 Bar News memoriam for Lilland QC, collectively they were to influence the development of the criminal law in New South Wales over the course of 3 decades, and then some. Your Honour is renowned for starting work at 4 a.m. and have earned a reputation for managing a prodigious workload while having a remarkable retention of detail. Your Honour is also highly regarded for being loyal to those with whom you have forged lifelong friendships. By 1987, Your Honour had risen through the ranks to become Deputy Senior Public Defender, whereupon Your Honour took silk in October of that year. This came just 7 years after admission to the bar, a remarkable achievement in itself. In 1988 came one of the defining moments in your distinguished career when Your Honour became Senior Counsel assisting the Royal Commission into Aboriginal deaths in custody. Recommendation 96 of the Commission's National Report, published in 1991, acknowledged the importance of improving the knowledge of all justice system participants regarding the wider social and historical context of Indigenous offending. The Royal Commission found that judicial officers should receive instruction and education on matters relating to Aboriginal customs, culture, traditions and society. As a consequence of this recommendation, in 1992, the Judicial Commission of New South Wales established the Aboriginal Cultural Awareness Committee, renamed Ngara Yura in 2008, of which Your Honour was chair from 2006 to 2012. The committee manifested Your Honour's often stated belief that justice, if not individual, is nothing, and that no effort should be spared to better equip judicial officers with information to deal with causes of historical, social and economic disadvantage and their relevance to individual cases. I need not remind the Court that 30 years have passed since the Royal Commission made its 339 recommendations. And just last week, the Bar Association publicly welcomed a report by the New South Wales Select Committee on the high level of First Nations people in custody and oversight and reviews of deaths in custody, but warned the time to talk is over, urging the government to act now to address systemic injustices for First Nations peoples. Upon completion of the Royal Commission, Your Honour returned to the private bar in 1990, taking a room in Forbes Chambers. In 1995, you were a founding member of Denman Chambers, along with Wayne Halen, Jim Nolan and Bruce Hodgkinson. Your Honour held a position as part-time Commissioner at Legal Aid, New South Wales, and served on a National Legal Aid Advisory Committee. A quick search found 21 reported cases in which Your Honour appeared, most often for the defendant. These included, well, there's a number of them, but they include Batiste, 35 New South Wales Law Report, Esposito, 45 New South Wales Law Reports, Kneebone, 47 New South Wales Law Reports, Veen and the Queen, number 2, and Wild and the Queen, both 164 Commonwealth Law Reports, and McAuliffe and the Queen, 183 Commonwealth Law Reports. As an aside, in 1999, when Justices Beasley, Bell and Simpson sat as the first all-female bench of the Court of Criminal Appeal, it was none other than Your Honour who was photographed by the Sydney Morning Herald at the bar table. As representative of the Bar Council, I cannot overlook Your Honour's valuable contribution to the policy work of the Bar Association, including Your Honour's chairmanship of the Legal Aid Committee in 1988, membership of the Criminal Law Committee and the Professional Conduct Committee. In conjunction with Peter Hidden QC, you formed the Aboriginal Education Committee in 1992 to work with the University of Wollongong on proposals for attracting Aboriginal people to the study of law. This was the first iteration of what would become the Indigenous Barristers Trust, the Mum Shirl Fund. In recent times, Your Honour's contributed to the Bar Association's submission to the ALRC inquiry into incarceration rates of Aboriginal and Torres Strait Islander peoples, as well as making a learned submission in Your Honour's own name. Your Honour was, of course, appointed the Judge of the District Court on 3rd of October 2000. It would seem that a transcript of Your Honour's swearing-in ceremony is elusive, unless you're the Chief Judge. Fortunately, the Bar Library researchers did not come away empty-handed, and I obtained a newspaper clipping from the Daily Advertiser in Wagga, headlined, Yabby Catcher, I'll get this right, Yabby Catcher made a judge. Now, I don't doubt the Daily Advertiser is a paper of record, so I read on. Your Honour was born in Sydney, but the family soon moved to Wagga, where Your Honour was raised. You were educated at Turvey Park Public School before your family returned to Sydney, and you completed your school education at Kogarah High. I also learnt that the, quote, former Wagga man, end quote, and soon-to-be appointed Judge Norrish had an interest in rugby league and catching yabbies. Your Honour is a notorious fan of the South Sydney Rabbitohs, and on a rare occasion when they lose, at least these days, you're said to be unapproachable for days. Your Honour played lock for Sydney University and by all accounts were a strong tackler. Alongside you were Paul Webb and Peter Miller, under the leadership of a man they called the Pair. My source wouldn't divulge whether that was by reason of his body type or indeed whether there was any reason at all. My research has also discovered that a book titled Taking It to the Streets, The Second Life of Newtown RLFC was, and I quote, launched with considerable elan by Judge Stephen Norrish QC of the District Court. I digress. Your Honour once observed at the CLE dinner in Armidale that retiring judges ought to be wary of deadly rejoinders from practitioners who have had to put up with poor judicial manners from time to time. Your Honour mentioned that satirists can seize on examples of judicial hubris and pomposity. Now that the moment of Your Honour's judicial retirement is upon you, I am pleased to say that there are no deadly rejoinders. By all accounts, assuming you were fully across the brief, it was not difficult to appear before Your Honour, even under the most trying of circumstances. Judge Norrish QC today is undoubtedly a great loss for the District Court bench. And the New South Wales Bar congratulates you and wishes you all that you wish for yourself in the coming years. May it please the Court.
Thank you, Mr. McHugh. Mr. Harvey.
May it please the Court. Before I begin, I too would like to acknowledge the traditional custodians of the land on which this District Court building stands, the Gadigal people of the Eora Nation, and to pay respects to country, and particularly for those that have cared for it for over 60,000 years. I come before the Court on behalf of the Solicitors of New South Wales, by whom you are greatly respected, to farewell Your Honour. To fully understand Your Honour's distinguished career at the bar and on the bench, it pays to reflect on the brilliant solicitor that came first. Your Honour was admitted to the role of solicitors in 1974 and served as a solicitor until 1980. This included 5 formative years at the Aboriginal Legal Service. Many of the things which Your Honour would become renowned for, the fierce, dogged advocacy, the profound understanding of criminal law matters, or the commitment to social justice, were either developed or evident in your early years as a solicitor. Those that know you best believe your legal education began not at university, but after the late Peter Tobin got you a job at the ALS. An honorary board member with a long association with that organisation has labelled it, and I quote, the best training ground for advocacy and one of the finest preparations for the bar that exists. That is, if you survived. More than one person acknowledged that in those early days the organisation adopted something of a sink or swim approach to supervision. Peter Tobin himself told Your Honour that if you lasted 1 year that would be good, but if you lasted 2 years that would be exceptional. Your Honour lasted 5. During those years, Your Honour was based in Cara and worked a beat larger than some European countries. From Dubbo in the north to the Victorian border in the south, from Queanbeyan in the east to Griffith in the west, not surprisingly, Your Honour spent a lot of time driving. This led to some interesting first impressions. One former ALS field officer remembers the first time he saw you, you were dancing on the side of the road with your hands in the air. As he got closer, he realised that Your Honour was in fact not dancing, but throwing sticks and stones at a huge snake as a small crowd began to gather. Now, he can't recall who got the better of it, the future judge or the current reptile, but it was just one of the many challenges Your Honour faced in this great open-air office. Your Honour once called the experience of driving out west metaphysical, and I'm reminded of the lyrics from an old Kev Carmody song, the enormous vastness of them inland plains gives you a lonely contentment to which you can't put a name. Now, field officers were the bridge that connected ALS solicitors to the diverse Aboriginal communities that they served. Your Honour is remembered fondly by field officers for your great empathy, your hard work and your ability to think on your feet. Assisted by them, Your Honour would develop a deep understanding of not only the legal issues Indigenous Australians faced, but of the Aboriginal communities themselves. Your Honour is modest on this point. In a paper for the National Aboriginal and Torres Strait Islander Legal Summit in 2010, you were at pains to claim no special expertise on Indigenous Australians. But, as a judge of the District Court, Your Honour would ask Indigenous men and women where they were from and inquire whether they were Kamilaroi or Wiradjuri or what people they identified with. Your Honour knew their country and had probably been there in your bright yellow Ford some years ago. Your Honour's prowess in advocacy also grew during these years as you represented your clients in many criminal law matters. Your Honour took this role seriously and prepared accordingly. A field officer remembers that police and prosecutors would tell each other, Norrish is on this one, better be prepared. In our adversarial system, advocates are critical to ensuring a fair trial, and Your Honour's life has given expression to this. A good friend of yours, who I'm informed joins us today, tells an anecdote that captures your passion for advocacy. At the time, he was working in a city law firm while volunteering with the ALS. One Friday night, he received a call and the next day dutifully appeared at court to put in the prerequisite not guilty plea and let the ALS lawyers do their work. But on this occasion, his client, accused of stealing hubcaps, asked to plead guilty. Your friend did, and the magistrate abruptly sentenced his clients to 6 months imprisonment. Early on Monday morning, your friend received a phone call from Your Honour. Decades later, the adjectives he reaches for are forceful and colourful. Your Honour was not impressed. Your Honour has always expected a lot from advocates, whether you're colleagues at the bar or the Public Defender's Office or as a judge on the District Court. As Your Honour is fond of quoting, justice if not individual is nothing. Good advocates never lose sight of the individual, even as they grapple with the limitations of the law or the complicated social, political and historical forces that might lead some to break it. In all your work and in all your roles, Your Honour has never lost sight of the individual, that each and every citizen of this country matters. As the immediate past president of the Law Society of New South Wales, it's my pleasure to publicly laud your sense of service and your commitment to the principle of equality before the law. I wish Your Honour well in the next step of your journey. I look forward to your continuing association with the Law Society of New South Wales as an honorary judicial member. On behalf of the Solicitors of New South Wales, thank you, Your Honour, for your service to our state. As the court pleases.
Thank you, Mr. Harvey. Judge Norrish.
Chief Judge, well, I too acknowledge the Gadigal clan of the Eora Nation as the traditional owners of the land upon which we now meet, and pay my respects to elders past and present and those emerging. Thank you so much, Chief Judge, for your very kind words and your organising of this farewell ceremony. I'm deeply grateful to you. I ran into the Chief Judge in the street and he asked me if I would have a farewell ceremony when he knew that I was resigning, and I said no, I didn't. I just wanted to go out quietly, but he wrote me such a lovely letter that arrived coincidentally the next day that I felt obliged to accept it. I'm very grateful that I did now. And I'd like to thank Lisa Freeman so much for all the hard work she put into organising today, and the Chief Judge's associate and the Chief Judge's staff for what they've done for me today. It's a great honour. It's very hard for me to believe that my non-parole period has expired and that the Chief Judge and the Serious Offenders Review Board has chosen fit to release me. And of course, it's a bit daunting returning to the scene of the crime. October 2000, it seems like yesterday. Here I am in the same position, but not with another 20 years of judicial service before me. There's a certain amount of a Groundhog Day feeling about it in one respect when you come back having been sworn in. You sit through swearings in and you see the people waiting to be sworn in being very nervous about it all, having to take the oath or the affirmation and the like, and you say, oh, well, I've been through that, I won't have to go through that again. And here I am. Mr McHugh, I thank you so much for your very kind words. I saw your father at the Forbes Chambers function, and in the brief words I spoke, I was able to quote something he did in the High Court when I appeared before him up in Brisbane many years ago. I admire you, and I admire your predecessors as well for performing the role of President of the Association. It's a prestigious and important position and becoming increasingly arduous over the years for the President. 2 years of service, unpaid, great disruption to your practice. I trust your commitment to your fellow members and the Association's goals is properly recognised by all members of the Association during your tenure. You're a shining example of what a President should be. I've been proud to be a member of the Association for over 40 years and greatly respect its role not only in the education of the profession, but also in undertaking other responsibilities, most importantly, its role in defending the rule of law and human rights. And while I speak of the rule of law, I commend everybody to read the speech of the Chief Justice at our District Court conference only a week or two ago. Mr Harvey, I also thank you very much for your kind words. I was a proud member of the Law Society for 6 years, and I regard the 5 years I spent at the Aboriginal Legal Service as the most character-forming of my professional life. And I've always had the greatest of respect for the solicitors of New South Wales, many of whom are here today and brief me. It's good to see that they've been prepared to come back and see me off, so to speak. I thank all my colleagues on the court that are here with me on the bench today. In the courtroom, sitting in the courtroom, we weren't able to accommodate everybody because of social distancing, and also live streaming. Hello to everybody that's watching from the far-flung chambers of the state. I greatly cherish the friendships I've developed with my colleagues, and I appreciate all the good wishes I've received both in person and in writing from them. I also acknowledge the presence of my wife Joanne and my children Claire, who is in Great Britain with her husband John. Hello Claire, if you don't mind me waving to her, she's watching online in Wales. It's midnight there, I believe, 20 past midnight. And my son Ben. I also have with me my wider family, my sister Megan and her husband Brian. My mother is 94. She's unable to be here today. She's very frail. She had a stroke last week, and I'm very sad that she's not here. My father passed away a few years ago. I would not be here today if it wasn't for the sacrifices of my parents over many years to enable me to finish school. I was the first person in my family to actually go right through to what was the high school certificate. I did the first high school certificate, but to matriculate, so to speak. And my parents provided for me through great difficulties in a marvellous way. I also feel that my mother's here in spirit. I thank all my friends that are here within the law and outside the law that have come. I can see so many faces I recognise. I've had a great deal of support from my friends throughout the year. In my family group over there, may I just acknowledge Phil Purcell, He and I met as Lions Club Youths of the Year in 1966. He was captain of Newington. I was captain of poor old humble Cogra High, and we've been lifelong friends. We went through law school together, and he was an inspiration to me in many respects. We have Anne Bowen here, whose father Lionel Bowen, along with Lionel Murphy, went right through Kensington Primary School with my dad. Lionel Bowen, who was to become the Deputy Prime Minister of Australia, was also Dad's solicitor. And we also have the Honourable Michael Kirby, who has a Kensington Public School connection. His father was at Kensington Public School half a generation before my father. I once argued a case in the Court of Appeal reported in the New South Wales Law Reports as Tomakakis and the Sheriff of New South Wales, a great miscarriage done to a Greek-Australian gentleman with English as a second language, where a judge took away all the money he'd put up for bail for the son of a friend, about $200,000, his life savings. And I took it to the Court of Appeal, and Justice Marr criticised the way the matter had been conducted because of what he described as a suffocating multiplicity of points, all of which are bad. Michael Kirby wrote, and it's in the New South Wales report, complaint is made about the number of points that have been made on behalf of the complainant. I make no such complaint. Legal ingenuity is the task of the advocate representing a just cause, and legal open-mindedness is the role of the judicial officer, not people being constrained by injustice and a misfired act. I was very proud that he wrote that for me in defence of me. So far as Joanne is concerned, I've never properly acknowledged my love for her and acknowledged the support that she has given me throughout our relationship, and I do so now. The truth of the matter is that over the last 40 years, I would not have been able to achieve anything at all in my personal and professional life without her support and her sacrifice, both professionally and personally. She's a microbiologist, but she, in truth, has sacrificed her career for me, to maintain our family, and to make it easier for me to pursue my career. I acknowledge the great love I have for her, and I acknowledge the great love I've received from my children Ben and our daughter Claire. Of both children, I'm incredibly proud. They've both attained honours degrees in law, something I didn't achieve at Sydney University. But then again, their mother's very bright. Jo is very much the person who's anchored my feet on the ground. She once pointed out to me shortly after my appointment that she noticed that when I was in the company of people associated with the law, but not other judicial officers, of course, they appeared to be more amused by my attempts at humour than they had been before my appointment. I suppose this is an experience for every judicial officer over time, but I imagine that this magical power will disappear on my retirement. Jeff Graham, a former judge of this court and the husband of my dear colleague Judge Tupman, said to me on my appointment over 20 years ago that I ought to be careful about what I did with my extended leave entitlement. He told me that 50% of it was for me and 50% of it was for my widow. Unfortunately for Joanne, she has not yet reached widowhood, but I do promise to share whatever lump sum benefit comes my way. I acknowledge the presence of other judicial colleagues from other jurisdictions, particularly the Supreme Court and the local court. I don't want to name anybody out of embarrassment, former judges of those jurisdictions as well as former judges of my court. The collegiality of judicial officers from all jurisdictions has been something that I've treasured. The interrelation with judicial officers of all jurisdictions at conferences, when sitting at the same court complex, such as in a regional court or elsewhere, is an important aspect of judicial life. Discussing common issues or matters relevant for educative purposes, for example, under the auspices of the Judicial Commission, has been very rewarding for me and all concerned. I, along with the colleagues of my court, deeply respect the industry and dedication of our judicial colleagues in other jurisdictions, whether we have the privilege to review their decisions or they have the responsibility to review ours. Common throughout our judicial life and world is the crushing relentlessness of work and the related pressures. It's a common feature nowadays of judicial function. Burnout and vicarious trauma are becoming more prevalent, I believe, and worthy of greater attention by us all. It is very important that we look after each other, and it's very important that we take an interest in our colleagues and their well-being and be prepared to help them when the need arises. I sincerely thank all of the associates who've worked for me since my appointment. Of those who work for me on a permanent basis, some of whom are here today, I mention Annette Gibson, Matthew Mather, Linda Hanson, Jack Byrne, Linda Head and latterly Jane Brown, as well as those various associates who from time to time filled in. I thank you all for your hard work and support. The dedication they have each shown to their work has been much appreciated by me, and I could not have completed my tasks without their valuable support and skill. In our court, the associates are really the bedrock on which the judges' work is based. I'm also very grateful to our tipstaves, David, Peter, Pablo and Zoran, for their selfless assistance over the years, as well as their predecessors, particularly Bill and Bob. Nothing has ever been a problem for the tippies, so far as I am concerned. I also acknowledge the support and industry of all the court staff and administrators, registry staff, sheriff and court officers. I've always been treated with the utmost respect and courtesy by all these people, and their contribution to the court's work is invaluable. I cannot thank everyone, will be here forever, but representing them, may I thank particularly Bob Finito, who runs effectively the criminal side of the court from an administrative point of view, Jane Dunn and Sue Mills in the civil side, Jennifer Garvey, Betty Cosmos, Peter and Jackie, the indomitable duo in the registry, as well as Daisy, Lorna and Mark. Rob is like the Wayne Bennett of the court, or perhaps the Michael Maguire, given that he's a Tigers supporter. He's always cajoling and encouraging judges to the starting barrier, replacing injured personnel, keeping the game moving along. He hasn't greyed at all over the years, despite the continual stress. I don't know how he does it. He remains forever youthful. Speaking of our court staff, it should be remembered that when COVID-19 became a reality here in mid-March last year, while many others connected to the administration of justice had the luxury of the protection of working from home, particularly legal practitioners and litigants, albeit some of those litigants were constrained in a home that they didn't want to be in. Our associates and court staff, court officers and sheriff's officers, and my colleagues as well, were required to come to work at courts around the state in circumstances of considerable uncertainty, particularly having regard to the horrors that were developing in the United States and Europe during March, April and May last year. To my mind, considerable courage is required by all those people in that uncertain period to support us in the work that we had to do, that we could not avoid, and these people had no choice in the matter. I have a great debt, as do all the judicial officers of this state, to the Judicial Commission and its staff, particularly its Chief Executive Officer, Ernie Schmatt, who is currently quite unwell, and to whom we wish all the very, very best. I believe Ernie's watching. I trust your recovery comes quickly. We also thank his Deputy, Murali Saji, Education Officers Ruth Windler, who's retired, and her successor, Una Doyle, and Kate Lumley, the Publications Manager, amongst others. Their assistance and guidance over the last 20 years has been of great support to all judges in the state. I was fortunate to have a 10-year or so association, as you heard, with the Negara Euro Committee, and deeply appreciated the guidance and advice of our Koori project officers, Tammy Wright and Joe Self, whose understanding of Indigenous cultural issues was so important for the success of the committee's work. The association I had with the committee provided me with the most rewarding educative experience I had in my time as a judge, particularly having the opportunity to work with fellow committee members from the local court and the district court and the Supreme Court, but particularly people such as Virginia Bell, who was the chairperson when I joined the committee, and my successor, Justice Stephen Rothman, a great friend of mine, John Nicholson and others. When I was sworn in over 20 years ago, I observed at the time, obviously lightheartedly, bearing in mind I was sworn in with Judge Balla, that I'd not fully appreciated how many friends her honour had, given the number of people who attended. On this occasion, I observed I didn't realise how many people were anxious to make sure I actually retired. I'm truly grateful for you all being here today, as I'm grateful to those people that are watching online. As the Chief Judge said, there's been much change over the last 20 years. We've had changes in technology and procedure. The technological changes, of course, have made our life easier, but have added to the urgency with which we perform our judicial duties. The good thing is that I think that technological change has made judicial officers more accountable and has made us better judges. Access to the internet has greatly expanded our access to information and has required us greater discipline in adhering to the dictates of the superior courts. Another significant change in our court has been the change in gender balance, which is of course a change for the better. But sadly, we lost our only Indigenous judge over 16 years ago, my friend Bob Belair, and there has not been an appointment of an Indigenous judge since. I hope this oversight can be corrected. There should be pathways for entry to the judicial ranks of First Nation lawyers, and we should develop them. We owe it to Bob to do it, and we owe it to the letter and spirit of the findings of the Royal Commission into Aboriginal Deaths in Custody that are 30 years old this month. Sometimes when judicial officers have the opportunity to have a formal farewell, they take the opportunity to make an important statement or make what they regard as an important statement about matters relevant to their jurisdiction or their function or their experience. It seems to me to be an act of hubris to criticise or comment upon some issue of importance at this time. I don't want to be seen to be speaking out of self-interest. I only have the interests of my court and the administration of justice at heart. However, I do wish to publicly state my hope that all persons concerned with the administration of justice will make a determined effort to act honourably, honestly and industriously in their allotted tasks. I'm talking not just about judges, of course, but about the profession and everybody else who has input into the judicial system. Because if everyone works this way with these objects in mind, they will do the interests of justice a service, whatever be the legislative constraints that exist. We need as judicial officers to be vigilant to ensure that the elusive goal of equal justice is attained. My appointment as a judge was announced in September 2000. That appointment had a very difficult gestation period. I'd been offered an appointment in April 2000 to be sworn in early May, but regrettably was unable to accept the offer, causing the then Chief Judge, Reg Blanche, QC, quite unnecessary consternation. I apologised to Reg. However, he did not give up, and eventually I accepted an appointment on the invitation of the Attorney General, Bob Davis. He has said publicly in the presence of other people that I was not only his first appointment, I was his best appointment. But then again, I think he's probably saying that about every appointment that he made, that it was his best appointment. As you can imagine, with the Olympic Games pending, my appointment was not a matter of public interest, save for the readers of the Wagga Daily Advertiser. Michael McHugh referred, he's taken away my best joke of the day, if you don't mind me saying so, but I'll come back to that. If my memory serves me correctly, the current Deputy Prime Minister at some stage was the editor of the paper they called the Tiser locally. I lived in Wagga from 1951 to 1963. My father during that period was what was described as a, quote, well-known sporting identity, close quote. He was a bookmaker. He'd been a prominent professional boxer after World War II. We only came to Wagga. He played football for Newtown when they won the premiership in 1943. But he only came to Wagga to take a job as a player coach with a local team called the Wagga Magpies, the only rugby league team in town. There's now about 4 or 5 rugby league teams in town, including the Kangaroos, for whom Tommy Raudonikis, the late Tommy Raudonikis, played in 1969. In any event, it was ironic that Dad should be coaching the Magpies because his middle name was Collingwood. Although not being an AFL supporter at the time, he probably didn't understand the irony. He did a bit of boxing refereeing. In fact, he refereed the very last fight of the great Dave Sands, who at the time was really the uncrowned middleweight champion of the world. He was to die a month after that fight in a motor vehicle accident on the North Coast. Ironically, in 1947, when my father was boxing, he was, according to the referee, a sporting newspaper of the time, the number 2 rated middleweight in Australia after Dave Sands. In any event, as you were told, the Wagga Daily Advertiser approached me for a story. I'll just give you a little bit of the detail of that without having to bore you. And the young reporter asked about my legal career and my personal circumstances and my modest aspirations. The very last question, I remember it very clearly now, was, Mr. Norrish, when you were a boy growing up in Wagga, did you ever dream of becoming a judge? I said, no, truthfully. I said, the only things I dreamt about when I was growing up in Wagga was swimming in the Murrumbidgee River, playing rugby league for Australia, and I can tell you at the age of 10 I'd already played about 100 tests in the backyard, whereas by that stage Clive Churchill had only played about 32 or 33 tests, and catching yabbies. The following day, as you heard, there was a substantial story of my appointment in the paper. The article had a headline in capital letters, "Yabby Catcher Made a Judge." I guess the time is right for me to go back to catching yabbies. My sincere thanks to all of you for being here in person and online. I wish everyone success and good health in the future, and offer my final thanks to all of you that have stood by me and helped me throughout my life. All the very best. Thank you.
Thank you, Judge. I invite you all to join us for morning tea. The court will now adjourn.
All stand, please.
How are you, Dennis?
I'm well, and you?
Good, good.
Still going around, I see.
Just, yeah.
I tell you what, your cases haven't got any easier.
No.
I thought there might have been a reward for long service in that.
Yeah, no, it's been great, but I want to have some time just doing other things. Apart from big matters.
That was dripping because I
Well,
know much about it.
there's no doubt